Thank you, Karen. Thank you, everyone, for being here. Thanks also to the Center for sponsoring this program. I come to this issue with a dual perspective. One is as a criminal defense lawyer who has tried and been involved in a significant number of terrorism-related cases in the Article III courts, the federal courts as we call them, and also as someone who was involved in the first military commissions in 2004, representing David Hicks, and then the second in 2005, and the third in 2005, and the fourth in 2006 and 2007, and have been following in an unofficial capacity the commissions that have evolved since then. And I think there are a couple of questions that people might have about military commissions versus federal courts, and these are the natural questions. One is, what's the difference between the two? And the second is, why the difference between the two, meaning why would you choose to try someone in an Article III court versus a military commission or vice versa, and what motivates the preferences. I think first you have to look at the evolution and the history of the military commissions that we're looking at now, which began, as Karen mentioned, with a military order by President Bush in the latter part of November 13th, 2001. But the military commissions themselves were not effectively instituted until mid-2003 at all, with a few military orders, but then 2004 was the first iteration of these military commissions that charged 4 detainees, Hicks, Hamdan, and 2 others who nobody really, their names might not mean anything, so I won't bother. But Hicks and Hamdan obviously have attracted a lot of attention, being the first 2 cases that actually went to conclusion as well in the commissions. Those commissions were halted by federal courts, habeas petitions by Hamdan and Hicks that effectively that succeeded in getting a stay from a federal judge. So in the fall of 2005, after the initial decision invalidating the commissions by a district court was overruled by the D.C. Circuit, there was some administrative changes, and then also in the fall of 2005, there was something called the Detainee Treatment Act, the DTA, which again had an impact on the commission. So already you're dealing now with 3 versions of the commissions before you even have a single adjudication of any of them. And then in the summer of 2006, again before a single case had reached fruition in the commissions, you had the Supreme Court decision in Hamdan, which had finally went its way up to the Supreme Court, and the Supreme Court invalidated the commissions on a variety of grounds, including the statutory authority that, unlike the commissions that President Roosevelt convened in the famous Kieran case in World War II, and other military commissions that were held after World War II with respect to both German and Japanese war crimes, President Bush had acted unilaterally. In addition, there were other more procedural and substantive deficiencies in the commission system that the court found in Hamdan. So it went back to the drawing board generally, although there weren't a lot of changes made. But in 2006, in the fall of 2006, the Congress passed what's called the Military Commission Act of 2006, which instituted version 4 of the military commissions. There were 3 adjudications in the context of that commission. David Hicks pleaded guilty to what's called material support for terrorism and went home to Australia 2 months later. Hamdan was tried and convicted essentially of material support and was sentenced effectively to time served, which is about 5.5 years that he had served at Guantanamo, and sent home to Yemen. And a third defendant, by the name of Al-Balul, one of the original 4, went to trial, represented himself, effectively presented no defense, acknowledged his membership in Al-Qaeda and his allegiance to Al-Qaeda, and was convicted and sentenced to life in prison. So those are the 3 cases. And then after the election of President Obama, he issued an executive order, I think his first executive order, as president, effectively staying all of the military commissions pending a review. And then in the fall of 2009, we had the Military Commission Act of 2009 with some further changes to the military commission system. Now, in terms of what's the difference? The difference, there are several differences between an Article III or federal court prosecution and a military commission. One is sort of the threshold is who can be prosecuted, and these military commissions are applicable only to aliens. No U.S. citizen is subject to these military commissions, which creates a discriminatory effect just as a threshold matter, and unconstitutional as far as those of us who have challenged the military commissions believe, based on a variety of different provisions, both constitutional and international. The rules in the commissions are different than the rules in the federal courts. In fact, there are no rules in the military commissions yet because the 2009 Military Commission Act has not been followed yet by a manual for rules. There was a manual for rules in 2000 after the 2006 Military Commissions Act, but that was never finalized either by the time we actually did Hicks. And in fact, in my last appearance in the military commissions in the Hicks case was not being permitted to appear on Hicks's behalf in April of 2007 because here we were about 6 to 8 months after the enactment of the Military Commissions Act of 2006. I was asked to sign a notice of appearance that said that I would abide by all the rules, including those that had yet to be written. And I declined to do so, and the judge would not permit me to appear. So rules are an important issue because the rules in federal court are rules that are promulgated by Congress that everybody knows, that are statutory or in the federal rules of procedure or case law that has been established by a 230-year history that has evolved. The military commissions doesn't have any of that. Resources is a very important issue in terms of what's the difference. In federal court, you are entitled to a lawyer, if you are indigent, you are entitled to a court-appointed lawyer in a capital case, which would be the 9/11 cases, as we've been informed by the Attorney General. Capital case seeking the death penalty, the defendant would be entitled to 2 lawyers, one of whom is learned in the law of capital cases, which is a very important reform of death penalty law as it was applied in the federal system, which has only had a death penalty in modern times since basically the mid to late 1980s. And the resources allocated in a federal case are extraordinary in terms of death penalty cases. Investigators, forensics experts, all mitigation experts who investigate family background, other issues, psychological background, all sorts, cultural issues. All that is required in the federal system. It is part of the framework of the capital resource center that exists for defense attorneys in capital cases, in federal cases, and also exists just as a matter of practice in the 20-year period that we've had the death penalty in federal courts. In the military commissions, in the previous system, before the 2009 Act, we had none of that. We had a military judge in the 9/11 cases who denied all requests for experts on the part of the defense in the 9/11 case, denied access to the defense to a variety of different experts and forensic issues, including the impact of the detention of their clients for 4 to 5 years incommunicado, hundreds of incidents of waterboarding for at least one of the defendants, and no mitigation experts, no ability to do any of the kind of research and investigation that is de rigueur in capital cases in the federal system. Another important distinction is evidentiary. Whereas in the federal courts, the Fourth and Fifth Amendments would apply to both statements and to seizures, and would obviously have there are other aspects of it, well, speedy trial, the question of outrageous government conduct, which exists as a principle in the federal system. I think there haven't been more than 1 or 2 cases in the almost 40 years, I think it's 40 years now, since the case Russell v. United States that at least recognize the principle, but it's a very difficult threshold to meet, but at the same time it does exist, and one could consider the application of that in federal cases. In the military commissions, again, not necessarily applicable, we don't know, but this is all a clean slate, but it's not really a clean slate, it's an unclean slate in the military commissions, given the history that we've had with them for the past 6 years.